everyone, to the LFJ Podcast. I'm your host, John Freund, Managing Editor of Legal Funding Journal. I'm joined today by Stuart Hills and Guy Nielson, co-founders of RiverFleet. It's a consultancy business specializing in the global legal finance market. Really excited to have them both here. I'm going to start, Stuart and Guy, I'm going to start by asking you to just please give us an introduction. Tell us a little bit about your background and what got you into legal finance and what RiverFleet is up to these days.
Well, John, thank you for the intro and pleasure to be here. My name is Stuart Hills, co-founder of RiverFleet. I'm a finance lawyer with, frighteningly 25 years of experience. I don't quite know where the time has gone. Mainly in legal private practice, specialising in private and public acquisition finance, project finance and restructurings. RiverFleet is a consultancy business specialising in the legal finance market, and we exist purely to help our clients navigate the actual complexities of that market. It's a tough market, it's a nascent market, and it certainly does take some navigating. And over to you, Guy.
Hi, John. Thanks for having us on your podcast today. I'm Guy Nielson, litigation lawyer, also over 25 years experience, combination of private practice and in-house litigation and contentious regulatory. So over 7 years at Freshfields Private Practice, Hong Kong, London offices, and then Merrill Lynch for 7 years, Director of Litigation, Regulatory Affairs for EMEA, and also head of the litigation for their investment management arm based in London. And then finally, over 11 years at HSBC, over 7 years of which I was Global Joint Head of Litigation and Regulatory Enforcement, with responsibility for managing the group's material litigation, exposure to litigation across the UK, EMEA, North America, Latin America, Asia, and the Middle East. I should also just mention briefly, we at RiverFleet have a strategic alliance with Edward Truant, who is CEO of Slingshot Capital. He has over 8 years active investment management expertise in the legal finance market. And he was also the founder of one of the world's first global commercial litigation finance fund of funds. So at RiverFleet, we have a very experienced team covering litigation, finance and structuring, investment management, portfolio management. And we think that our broad expertise across those areas are tailor-made for a global client base, including investors, litigation funders, corporates, law firms, to name just a few. And I think more details can be found on our website in terms of the different types of legal services that we offer for that global client base.
Yeah, Ed is a friend of LFJ. He's been around for a long time. He's helped us. He's contributed a lot of content. He's moderated some of our events, some of our digital events. So any friend of Ed's is a friend of ours. So
great.
Both here. You mentioned the global clientele. Let's start there. Probably the hottest topic right now in the global litigation finance sector is the regulatory pressure that's coming down both in the US, in the UK, and elsewhere. I want to ask you both who you think is behind this. What are the contours of this? What is your sort of take on the current moment for litigation finance?
Well, why don't I just...
Do you want to have a start?
Yeah, I'll have a go. Let's try and first of all look at some of the challenges that the industry is facing. I think if we can get to the bottom of that, we'll have half a chance of working out who we think might actually be behind it. And it isn't just a regulatory pressure that we're under, there's a financial pressure. And probably just as importantly, there's a reputational pressure. So let's first of all talk about financial. And we can't really go any further without starting with our friend Senator Tillis and his attempt to tax litigation finance funds. Now, thankfully that failed, but the attempt must surely be a wake-up call for this industry. Have we dodged a bullet? Not really. Pretty soon after that failure, the baton was picked up by some insurance chiefs who continued to argue that the proposed tax could have helped level the playing field. Now, level it with whom, they didn't really say. They said the claimants, but actually what it would mean is that litigation finance funds would have been treated differently to other funds, which surely cannot be right. And the issue that faces, because it isn't going to go away, is an existential threat to the whole of this industry. So the first tag of who is actually responsible, well, it's politicians. Followed up pretty quickly by Congressman Darrell Issa reviving his Litigation Transparency Act, trying to make mandatory public disclosure of any outside finance in civil lawsuits, along with the identity of the backer and the terms of any litigation funding agreement. Now, as we all know, broad disclosure of any of those sorts of terms would probably drive funding elsewhere. So we have to treat that threat as seriously as we treated Tillis. Reputational criticism can broadly be broken down into three common claims. And actually, this is often ignored, but for us, this is a really important point. Firstly, and it's often said, even in bland reports, that it inflates legal costs. We ignore the fact that pressure on fees for lawyers has gone up over 40% in the last 5 years. We ignore the fact that only 1% of litigation spend is actually funded. So how it can be responsible for inflating legal costs is a bit weird. Secondly, that it fuels unmeritorious claims. The very purpose behind litigation funding is to do their very best to find meritorious claims. It is a nonsense to turn around and say that the business case is to fund unmeritorious claims. And yet you will often see that allegation. And then thirdly, that it is not an effective redress mechanism. A common example quoted is the post office litigation over here in the UK, and yet Mr. Bates himself is an advocate for litigation finance. Again, nonsensical. And we also face regulatory pressure. The CJC is recommending regulation, as you say, the intro to your question, John. But putting aside who's actually making those allegations, our biggest issue is actually the constant repetition of baseless charges. You can read them in every report that ever goes out talking about litigation finance, but it has the effect of turning baseless charges into presumed fact. And we have to recognize that threat, and we have to do something about it. So yes, I think the industry is under pressure, it is under attack, but it isn't just regulatory. And in some ways, and we can come on to this a little later, the pressure of regulatory change, the pressure of having to introduce legislation, in some ways could be turned to our actual advantage. And we can sort of come on to that later.
Yeah, so I guess the question for the funding community then is like what to do about all of this. What should the response be? And you mentioned like the baton is being picked up now. It's sort of dodged a bullet, but maybe just momentarily. So what should the industry response be to all of this?
It doesn't really matter what name you call it, whether you want to call it lobbying, whether you want to call it rebuttal, communications, PR. It's all the same thing. We have to get our story out there in a better way and in a more consistent way than we have previously done. Now, we have to, whenever we see an untruth said about our industry, we have to rebut it. So if you look at the lobbying that went on around the Tillis Act, the ILFA, backed by some major funders, that was pretty effective for that particular instance. And we have to replicate that on an ongoing charge to make sure that we rebut those baseless allegations. We can also attempt, although I say this with some hesitancy, to be more transparent. But that's not such an easy thing to achieve. Many of our investors demand privacy, quite rightly, as they do in every other fund that they sort of invest in. And although we have nothing to hide as an industry, there is also data that we would not want to be obliged to disclose to the other side because it gives up your tactics for your whole of your litigation case. And we have to recognize that the very asset class that we are investing in, which is litigation, is inevitably working in a highly confidential arena. And we help no one by sort of promising glibly that we can give total transparency. We shouldn't, and we must resist to, because it would be wrong for all sides. So the simple truth, what should we need to do about it, is we need to be better at telling people the benefits of what we do. and we need to improve on that quickly.
Interesting. Well, I want to touch on the UK at the moment, which is where you're based. And the CJC's final report, it made a number of recommendations for an overhaul of the industry there. So I'd just like to get your take on those recommendations.
Well, if I could just make a couple of high-level general observations to start with, and then touch upon some of the examples that we see as positive takeaways, and then look at some of the examples of recommendations that give us cause for some concern. In terms of sort of general high-level observations, I think anyone who's read the report couldn't help but recognize that it is a quality piece of work. It's hugely detailed. It's very thoughtful. It's an evidence-based approach that they've taken, and it's very clear that numerous different stakeholders made submissions with very strongly held diverging views. That comes across very clearly, and I think the CJC have done the best that they can to try to find the right balance between sort of recognizing that the industry has a pivotal role in relation to promoting access to justice. There's a need for a framework that recognizes the need for a framework that is commercially viable for funders, and it also needs to have the right protections for its users. I think, again, as a general observation, the way that they've clarified that there needs to be a real distinction between the regimes for funded parties, where the funded parties are commercial parties as opposed to consumers. I think that makes perfect sense. And they also clarify that there's third-party funding by a funder on the one hand, and there are contingency fee arrangements on the other, which includes DBAs. And I think that is a very clear distinction that needs to be made, the need for different regimes in those respects. So some clarity, at least, in relation to the whole debacle that PACCAR created in terms of some of the confusion that lies in terms of underlying policy intention. So I think that's all good. Look, in terms of the positive takeaways, I mean, we're approaching today very much with the regime for commercial parties being our primary focus. If you look at some of the positive takeaways, clearly there's a lot to applaud. So no caps on funders' returns, no caps on success fees for lawyers acting under CFAs and DBAs where the clients are commercial party. Legislation to be introduced both prospectively and retrospectively as soon as possible to reverse the effect of PACCAR. No presumption that security for costs should be awarded against litigation funders or funded parties. Limiting funders' liability for adverse costs to the amount of funding that they've provided. And in certain circumstances, recoverability of litigation funding costs. And they also express a recommendation that there's no need for any state level regulation and funding in arbitration. So on the face of it, there are a lot of very positive takeaways. Nothing's guaranteed that they will all necessarily be implemented, but on the face of it, I think there's a lot to applaud and be cheerful about. But what about our primary concerns? Well, CJC describes the proposed regime as minimal for commercial parties and light touch. And I'm not sure that is an appropriate characterization when you really dig into some of the detail. I mean, what are they really recommending here? They're recommending a code of conduct, effectively encapsulating the ALF code of conduct and the ELI principles. And that code should be underpinned by new litigation funding regulations that are going to have teeth. And what are those teeth? Well, if you breach the code, the LFA is unenforceable. And that seems pretty draconian to us in terms of what is being characterized as minimal and light touch. If you I mean, there is a proposal that the courts might have discretion to waive a breach in certain circumstances, but there's no clarity as to exactly how that would work. And it's going to depend on the precise drafting of the regulations. And what we absolutely do not want is a repeat of what we saw with the current DBA regulations, which have long been criticized for being so opaque and draconian in terms of the unenforceability provisions, and not reflecting the actual intent. So it's absolutely imperative, it seems to us, that there is real clarity surrounding the drafting of the regulations and exactly what is proposed. Now, as regards, perhaps an example of a particular code that, people should think about quite seriously. I mean, Stuart, do you want to touch on the sort of prohibition that's in the code in relation to controlling funders, both, directly and indirectly in relation to litigation?
So let's touch upon the issue of control over litigation in the way that that's dealt with. So it doesn't really matter what report or code you read. The tone of all of them is pretty much the same when it comes to control over litigation. And it's all along the lines of a package of things that says, do not seek to influence the funded party's legal counsel, do not control directly or indirectly the overall litigation. The funded party should be the ultimate decision maker in the case, including settlements. Terminate if you think it's commercially unviable, terminate if merits change. So the general view of all these codes and principles is to hold the funder at arm's length, which I have to say, in the year 2025, if you ignore legal history for 1 second, if you ignore championing and maintenance concerns, it does seem a little odd to hold a funder at arm's length from the very asset that it is funding. Now, let's take an example, a very simple one. Let's say you go to a bank and you say to the bank, I want to borrow some money to go and build some luxury apartments. But guess what, bank? I want the ability to change the builder whenever I like. I want the ability to not build luxury apartments, but I might build student accommodation, change the whole economics of the outset. It's still commercially viable, but I want the right to change it. I mean, no bank is going to touch it. And that's what we're being asked as litigation funders to do. So we think we're at the point in time of this market where actually we should completely turn things around and make use of the actual legislation that is coming our way to legislate to turn around the control issue. Rather than holding us at arm's length, embrace us. Except that for commercial parties, there are a good list of items that the funder should be able to control. Now, you can easily go through a list, but they certainly do. What do funders care about? They certainly do care about settlements, and that should be recognized. They do care about who is the legal counsel, and that should be recognized. They care about the way the case is being run. They care about discontinuing the legal action, and they care about wider matters affecting the funder, their solvency and other such issues. And that's just to name but a few. As Guy has said, sophisticated entities should be free to bargain as they see fit. And the way that funders are treated needs to evolve. Funders are smart, sophisticated entities with a wealth of litigation experience, which should be harnessed and not held at arm's length. And to say, with that legislation coming our way in the near future, and it certainly looks like that it will do, let's make use of that to deal with an issue like control and change around some of these outdated control concepts that people still keep on banging on about.
John, can I just jump in quickly with just a couple of other additional issues of concern, just to touch upon very quickly? I mean, Stuart's kind of alluded to one of them in relation to the disclosure of funding agreements. And look, the report recommends that the existence of funding and the identity of the funder be disclosed, but not the terms. That all seems sensible, to us. But it goes a step further in terms of requiring the underlying source of the funding to be disclosed to the defendant. And as Stuart has alluded to, we think that is not actually an innocuous point. It is potentially a tipping point for funders and investors because of the need and importance of confidentiality. So I don't think people should underestimate the effect of that. And perhaps a compromise, if people wanted to think about one, was some sort of agreement that in exceptional circumstances, the underlying source of the funding might be shared with the courts for the courts to decide any issues of conflicts of interest, for example, but absolutely not that it should be required to be disclosed to the defendant. So that's the first point. I think the second point is, let's just think about this retrospective legislation that has been recommended for a minute. I mean, I think first and foremost, people shouldn't underestimate that there is likely to be a challenge because there's a presumption under English law that retrospective legislation should not be implemented. And there's a good reason for that. It's because it creates certainty. If you start to change the law going back in time, you change people's rights and you can get yourself potentially into a bit of a mess. So that's the first point. I think the second point, I mean, talking about how you could get yourself into a bit of a mess unless people are very clear about what this retrospective legislation is intended to achieve. Just think for a minute of the different scenarios. I think too simplistically, some of the funders that we talk to think that, well, it just kind of affects those situations where pre-PACCAR, you effectively reverse the situation so that you re-enter into the commercial basis of the litigation funding arrangements at that moment of time that was subsequently deemed to be unenforceable. But it's more complicated than that. As we all know, the reality is that so many existing litigation funding agreements at the time of PACCAR in relation to ongoing cases have been renegotiated and amended for a very good reason, either to comply with the DBA regs or to be expressed as a multiple, as a workaround, if you like, because of the problem with the return being calculated as a percentage of damages because that falls within the DBA regime. But think about it. When the bill was first introduced to Parliament in early 2024, when there was an intention at the time to reverse PACCAR, people raised all sorts of issues about overlapping agreements and those cases where it was felt that consumer-funded parties in particular had no choice but to renegotiate their LFAs on more onerous terms. So people will inevitably raise the question as to whether or not these re-amended agreements should subsist as they are, or whether there ought to be some kind of mechanism for retrospective legislation to give effect to the original unenforceable terms. I think the other thing that just concerns us a bit, we're all aware of all the satellite litigation at the moment that is also ongoing in relation to whether multiples of sums invested could also be LFAs that are DBAs and hence unenforceable. Court of Appeal at the moment is in favor of the funding industry. I'm not sure yet whether it will be accepted at the Supreme Court level for them to determine it once and for all. But God forbid we have a situation where ultimately the Supreme Court could determine that multiples are also unenforceable. And then you have a situation where you have two unenforceable LFAs. You've got the original one that was damages based, and you've got the second one that was multiples based. And in those circumstances, think about it. Is the legislation intended to revert in relation to the first original LFA, or does it retrospectively affect the second LFA? So we just think that, these are issues that I don't think people have thought through enough. And I think that there needs to be an engagement to ensure that there is clarity in relation to any legislation that is implemented retrospectively.
Yeah, and so let's look at on the consumer regime specifically. What would you say is your number one concern regarding the recommendations there, as far as that aspect of it?
So, I mean, Look, certainly my number one, I think, concern is that the report is really clear that there should be no prior engagement from funders to funded parties. And I just think that, consumer funded parties just don't have the resources and the ability to identify cases that are strong cases where litigation funding could help them. So I think to prevent litigation funders from being able to even approach consumer funded parties in terms of explaining to them all the underwriting that they have done. And let's not forget, they do it for a very good reason, to invest in meritorious claims, not frivolous claims. I mean, it's just a nonsense, as Stuart said, to think, particularly in those jurisdictions where the loser pays the winner's fees. If the funders lose a case, they're on the hook for the adverse costs of the defendant. So it's just a nonsense, it seems to us, to think that there would be, any value in a funder pursuing a claim that didn't have merit. So just in terms of an access to justice issue, we think it's short-sighted because the effect of this prohibition is actually, we think, going to reduce the amount of litigation funding that could be made available for very good cause. I think that's the first point. If there's one other quick point to make, there's a recommendation in the report that the consumer-funded parties get an opinion from a KC, so from a barrister, in relation to the viability of the case, make sure that the consumer-funded party understands the terms, etc. But the worst thing about that is that there's a requirement that the funder pays for all of that. And you have to say, well, why, when they'll do their own underwriting process anyway? There's also a recommendation in the report that in any event, the court needs to sign off on the fairness and reasonableness of the terms of the funding arrangements. So this requirement is just going to add significant costs for the funders. It's going to cause additional delay as well. And we just think that that is both unnecessary and short-sighted in terms of what could be actually quite a significant deterrent for funders when it comes to their decision as to whether or not to provide funding to that consumer-funded party.
Yeah, and some have speculated that deterrent was really being pushed by the insurance industry. Now, we know that the insurance industry, on the one hand, has been a big investor in litigation funding, both in some funders globally, and then also just in terms of partnering with the industry. And, there's a lot of insurance products that have been offered in the last several years, although some of those, we've seen some insurers now exit the industry. So there's been some tension there. There's always been some tension on the other side of the coin of that, of course, that the insurers are the ones who often have to foot the bill for these larger settlements that take place because of litigation funding. So there's a really complicated sort of relationship between insurance and litigation funding. And I just want to get your take on this. How do you view insurers vis-a-vis litigation funders? Are they friends? Are they enemies? Are they frenemies? Are they something else entirely? How would you frame it?
There are certainly some people who, in the insurance industry, who see litigation finance as the enemy. We've all seen many articles recently upping the ante on that very issue. And of course, if you primarily act for defendants or you insure defendants that are being properly held to account, and that's led to an increased insurance cost, well, then you're not going to like it. I mean, some of the tension has actually arisen out of judgment insurance. Now, previously, that whole round of insurance underwriting was working very well. It was nicely diversified. But as they started to write bigger underwrites, and those underwrites went the wrong way, that dwarfed a number of the smaller deals that were actually going along quite nicely. So in some ways, it was just a lack of diversification that led to that issue. And rather than throwing the baby out with the bathwater, it'd be nice if they could get back to the way that they were writing those cases before, sort of underwriting those pieces of insurance before. Bigger diversification, less concentration, and that was working very, very nicely for people. So we know that insurance and litigation finance work in the same field. We at RiverFleet think that they do different things and they should continue to do different things. One underwrites risk and one provides finance and expertise in choosing the right case. And there's no reason why they can't continue to work together. And I think in many instances, they are working nicely together. That is continuing. And so the synergy between the two should, in our view, be harnessed, helping to shape the future products that they can actually work on as a group. So are they enemies? No. The vast majority of the industry don't see them as enemies on either side of the camp. There are a few noisy voices right now. And I think we just have to not overreact to that.
You've written in a recent article that, I'll quote here, the aim of all of us is to help create a legislative platform that supports a world-leading litigation finance industry second to none. You've also been talking here about just the attack the industry is under, financial, regulatory. This seems to be an inflection point for the sector right now. I think most participants would agree. So what do you see when you look forward in over the next year or 2 years of the industry? What do you see?
I think, John, look, obviously there are a lot of known unknowns right now in terms of how things are going to play out in the US and the UK, in terms of the political and regulatory scrutiny. And that's a real concern because we're talking about the two largest TPF markets, right? The US and the UK. And how that plays out is going to have consequences, good or bad. But in terms of, I think, some fair assumptions that you can make, notwithstanding that uncertainty, I think there are a number of things that we see in terms of development sort of going forward. Look, I think it's inevitable that regulatory scrutiny is going to lead to additional compliance and administrative costs. I think it's inevitable that there are going to be increased resources required to invest in more AI analytics and technology. We're already seeing that that's revolutionizing case assessment and risk management. I think we're going to see an inevitable greater need for funders to diversify and expand geographically to manage the systemic jurisdiction risk that we've been talking about. I think there's going to be a continued demand for more portfolio deals, for more sophisticated and innovative products. I think there are going to be more corporates seeking funding for working capital and balance sheet management purposes, particularly during times of any recession, if there's a recession that comes along in the medium to longer term. And we're seeing more pressures on the availability of capital and the need for robust funding models. I think these are all fair assumptions to make. So if you take all those factors as a whole, I think it's likely that we're going to see a lot more consolidation amongst funders in an industry that I think is poised for growth, but also transformation that's going to be driven by economic, technological, and regulatory shifts. Stuart, is there anything you wanted to add, perhaps mention secondary markets in particular?
Yeah, I want to take a step back first of all and just re-echo the point that we made earlier, which is if legislation is coming down the track, how can we best make use of it for this industry? There's a few things we should be thinking about. The first one I want to talk about is regulatory structure. There was some mention of it in the report, but actually we would like to propose something actually a little simpler. There still needs to be, in our view, a two-body structure for any regulatory structure, one to administer the industry and one to be a sanctions body that can offer quick sanctions. Similar to the way that the legal profession in the UK is already administered by the Law Society on one hand and the Solicitors Regulation Authority on the other. And there seems to us no reason why we couldn't use that structure again. In fact, there seems to us no reason why we couldn't broaden the remit of that existing structure of the Law Society and the SRA to actually be the governing bodies for our industry. It exists, the structure works, it's effective, and we haven't got to reinvent the wheel. So we'd like to see some thought given as to whether or not that regulatory regime could work as expanded into the litigation finance industry. I want to finish off with a couple of points. One is to talk a bit about secondary trading. Again, thinking in terms of how we could use legislation. Now, we know that duration risk is a real concern for most funders. And one of the tools that you can use to deal with duration risk is a robust, effective secondary market. But that's a difficult thing to achieve. There needs to be a balance between an ability to share information on the one hand with professional market traders, whilst maintaining the confidentiality of that data, and something that allows trading and maintains legal privilege. That structure can be done, but it's going to be best done through legislation. And it would be lovely if we could have a debate around including secondary market regulation legislation within the current act that hopefully will be coming forward. And I finally want to say one thing, which is echoing the likes of what people like Invenio have been saying in recent times, which is, the fight is now. And we echo that theme quite strongly. Now is not the time to sit back. If we want legislation to do something, to say something, now is the time to tell government what we need it to do. Now, how we corral ourselves, how we step forward with a consistent voice is a key issue, but we might want to look at how we handled Tillis and start from that. The ILFA, backed by some of our major funders, did a fantastic job at lobbying, a small enough group that could be effective when making actual choices, a big enough group to be representative of our industry. We also have very bright people in our industry. We could perhaps even draft a bill and send it to government and say, look, let's debate this. This is the way forward for our industry. This is what we need to take a step forward. Now, if we can do that, if we are proactive in that measure, then we really do stand a chance of getting legislation that will work and will make us a leading litigation finance market. Get it wrong, we know investors will go elsewhere. They have choices, and we want their choice of investment to be into this market. Funds will go elsewhere, and access to justice, if we get it wrong, will simply be denied, and we can't allow that to happen.
Yeah, I think if anything, my hope is the funding community learned the value of, like you just said, being proactive and not hesitating, sort of digging the well before you get thirsty, because there was such a mad dash at the end to avert that horrible tax inside the big beautiful bill. And then we see some of the regulation, like you said, in the UK. It's just really important to get ahead of all of this. And I have heard other members of the community say that, so it's great to hear you voice that. We need more of that. So Stuart and Guy, thank you both so much for coming on here, sharing all of your thoughts on the current state of the industry, the challenges we all face, and what funders can do, the action items people can take within the industry. It's really very helpful. We appreciate it.
Thanks, John. Thanks for having us. It was a pleasure.
Absolutely. We hope you enjoyed this episode. We'll see you on the next episode of the Legal Funding Podcast.